Good afternoon, everybody. This is Rob Solt, and I'm here with Carl Habekost, and we're going to present a webinar today addressing when workers' compensation claims morph into the ADA and the FMLA, alphabet soup. I think really more than workers' compensation claims morphing, it's more about what laws apply and how you utilize all that information. Before I get started, though, I'd like to thank Carrie Ramirez, who's helped put this presentation together. And for those of you that have watched many of these presentations, you know what a wonderful job she does. And she's in the background and makes this work. As those of you that know Carl and I are well aware, that wouldn't be us in this scenario. So it's a pleasure to talk to you today about these issues. And a couple things before we get into the presentation. I think, as everybody is aware, COVID-19 has affected everyone in their lives in some way, shape, or form. We've had nothing like that since probably any of us have been alive, and it's unfortunately not going away soon. We're very hopeful that vaccines will come about and a lot of different things will happen, but as we sit here today, I think most of the information is trending that there may be an uptick, a continued uptick and all that. So this information is really relevant and important. Okay, I think we're ready to start into the presentation now, if we could. Carrie? What we're going to talk about today is the intersection of workers' compensation, the ADA, and the FMLA. As you'll see from the next slide, each of these areas of law are distinct. When you look at these laws, and as the next law will show you, the Workers' Compensation Act has been around for a long time. It was created in 1913, and it essentially was a program that was designed to pay benefits. The state law that we have was not intended to deal with COVID-19. COVID-19, even though we had a flu epidemic in 1918, was lasting from people's minds. And so as we go through this, we'll talk about whether COVID is actually an injury or an occupational disease and whether or not it's compensable. And we'll also talk about some of the political realities of what's going on here in the administrative process versus court. Now, Carl's going to talk to you a little bit about the ADA and the FMLA.
All right, thanks, Rob. Good afternoon. The ADA stands for the Americans with Disabilities Act. The ADA was also amended, so now we have more alphabets, ADA, AA. But at any rate, that particular law is a disability law. It's, as we will talk about in these different slides, it's administered by a federal agency, the EEOC, and the purpose of that law is to ensure that individuals with disabilities have equal access to buildings, to employment opportunities, and that they are not discriminated against. Ohio also has a corollary law that protects disabled employees under the Ohio Fair Employment Practices law. It's found in chapter 4112 of the Ohio Revised Code for those of you who are actively interested in doing research. We'll talk a little bit about COVID-19 and how that intersects with workers' comp and the ADA as we move along in the presentation. The other law we're going to touch on today is the Family Medical Leave Act, FMLA. All of the HR specialists' favorite part of their job. That's a joke. I can hear you laughing out there. Intermittent leave especially. And once again, the purpose of this particular webinar is to really touch on the different laws and how they interact. And in subsequent webinars, we will get more in depth on each one of these areas. Now, when you think about workers' compensation, it's pretty obvious for those of us who are in the business that workers' compensation involves medical information. Also, the FMLA involves medical information. The Americans with Disabilities Act is governed by medical issues, but the employer is limited as to the inquiry of someone's medical condition and whether or not they can get medical records, which sort of begs the question, can an employer test employees for COVID-19 reasons due to the pandemic, or are they precluded from doing so by the ADA? The short answer to that question is yes, employers can test for COVID-19 as long as it is job related. It's a necessary function to protect people in the place of employment. So we'll get into more of those details in a minute. Now, as Rob Solt is going to touch on later in the presentation, there are two primary modes of having a claim allowed in Ohio under the Ohio Workers' Compensation Law, and frankly in any of the different states. The first and the most common that we are aware of is an injury. Many people think of an injury like a slip and fall. You trip, you fall down, you have an acute incident, and you have an injury. It's related to work. That's sort of got mixed up a little bit in the, I don't know, late 80s, early 90s, when the Ohio Supreme Court came up with this concept of a wear and tear type of injury. A cumulative trauma is another way to describe it. Somebody over time develops carpal tunnel syndrome or elbow problems, but that is still known as an injury. An occupational disease, which Rob Solt will get into shortly, has an entire different analysis. It can be quite complicated. It even has its own statute of limitations. But those are the two primary ways of coverage under Ohio workers' compensation. Now, when we were talking about the Americans with Disabilities Act, disability obviously is the primary word we need to be concerned about. Well, what in the world is disability? How do you know if somebody's disabled? Well, this may seem like common sense, but for those of us in the business, it is not common and it doesn't make sense a lot of times. Somebody has a physical or mental impairment that substantially limits one or more major life activity, such as breathing, walking, seeing, hearing, and yes, even working. Or they have a history, a record of having such an impairment. And here's the more recent thing that employers are running into, that the employee is regarded by the employer as having such an impairment. So if the employer treats the employee like they have a disability, even if they don't actually have it, they are covered under the Americans with Disabilities Act. The Family Medical Leave Act, and that has recently also been expanded. We will touch on that during COVID-19 pandemic times. Something called the Family's First Coronavirus Response Act. But the old standard FMLA was a law that was passed in the early 1990s, and the purpose of that law was to help employees juggle the different responsibilities they have in today's work world. So an individual can take the standard FMLA, individual can take up to 12 weeks of work off and have their job protected. But you have to have a serious health condition. And there again, here we go. What does that mean? That can mean anything from migraine headaches that coincidentally appear on Fridays and get cured on Tuesdays, or pop up on Monday and pop up on Friday afternoons. The key to this is medical documentation. It is a time-consuming, energy-consuming burden for many HR individuals. The point of this slide that I'd like to bring out is the very last little box down there. Any period of absence to receive multiple treatments, if not rendered, would likely in a period of incapacity to be greater than 3 consecutive calendar days. Most commonly, we think of more serious issues, chronic issues like chemotherapy, kidney dialysis. And frankly, think about it. Does that also qualify as a disability? Somebody has cancer. Are they also protected under the Americans with Disabilities Act? Probably. What if they got their cancer at work? What if they were exposed to some airborne chemical, or through contact with cleaning solutions or whatnot, they develop cancer? So that you could, in this instance, have workers' compensation coverage, FMLA coverage, and the ADA coverage. But beware of the FMLA. It is a minefield of problems. And enough of that. We'll touch more on that as we move along. Now, as Rob indicated at the beginning of our presentation, this really is an informational webinar as much as anything, because we're all burdened with a lot of information in today's world, information overload. And sometimes we forget just to take a step back and look at things. Well, the ADA, as I indicated, is a disability and discrimination-based law. So the EEOC, federal agency of the government, administers that law. The and there is an Ohio corollary, since most of the people attending today are in Ohio, although I do believe we have some Michigan people and at least one hillbilly from Alabama I know is on listening. Mr. Ellswick, thank you. The FMLA is once again administered by a federal agency. This is the Department of Labor Wage and Hour Division because it is a leave law. Well, then you have workers' compensation. That's administered by each individual state. Most states have private insurance companies administer workers' compensation. In Ohio, we have a monopolistic system that is administered by the Ohio Bureau of Workers' Compensation. That agency seems to be giving out refunds, and I think there's a big one due out this week. Yeah. I think, Rob. At any rate, the workers' compensation program is different in every state, but we just wanted you to be aware of that. And let's talk about employer coverage, because just merely the existence of these laws do not necessarily mean that an employer is covered or an employee has access to these coverages. The Americans with Disabilities Act, or also the ADAAA, the employer must have 15 or more employees for 20 weeks during a current or preceding calendar year. In Ohio, once again, that is 4 or more employees. And the coverage is very similar to the federal program. FMLA, this is a little weird thing in here. That the employer must have 50 or more employees within a 75-mile radius for at least 20 weeks. Now, there are a couple of things. The 50 or more employees can be spread out amongst 2 or 3 different facilities. So if an employer has 20 employees in one facility and 15 miles away has 30 employees in another facility, then they are subject to the terms and conditions of the FMLA. I would also say that some employers simply abide by the FMLA if they don't have 50 or more employees. You can always provide more than the law requires. You can never do less. Also, one little quirk, the employer can define its own calendar year. And there are multiple ways to do that. We can get into that in another webinar. Workers' compensation applies to everyone who has an employee, and we get into this quite often, don't we, Rob? Whether somebody is an employee, whether they're an independent contractor.
And I think we're going to do a separate webinar on this, but something you may give mind to is how many of you have people that work remotely? How many of you are working remotely today? How do the laws affect that? The employer does not have control over your house. Are you in the course of it? Does an injury arise now of the employment if you trip over the dog walking out the door? There's a lot of unanswered questions, and I think we're going to plan on doing a seminar addressing all those issues or webinar in November. So
Right.
keep that in mind.
Good point. Employee eligibility. We've covered employer coverage. So now, how does an employee enjoy the benefits of these laws? Well, under the ADA, it's pretty simple. If the employer is covered, the employee has to have a defined disability under the ADA. As long as the employee can perform the essential functions of the job with or without a reasonable accommodation, they are covered by the ADA. That means that you have to have up-to-date and well-defined job descriptions. FMLA, individuals have to work, emphasis on work, not take vacation, not be away from work, but they have to actually work at least 12 months and have 1,250 hours prior to the start of the leave. Workers' compensation, you can be covered under workers' compensation the very first minute on the job. We have a lot of those claims. Always kind of brings up credibility issue. If somebody is 1 hour into the job and they claim a back injury due to an unwitnessed incident, brings up some credibility, doesn't it?
You can. We've had claims where they're going through training and
That's
they
right.
aren't even on
That's
the
right.
clock yet.
Yeah.
Is that a compensable injury? So
Yep.
it can come very quickly.
Length of leave. Each one of these laws has a component of leave to it. Believe it or not, the ADA does have a component of leave. The courts have indicated that somebody may need just a little bit more time off as a reasonable accommodation for their job. The FMLA, of course, we know that there's at least 12 weeks in there. If you're a service member for military leave, you get up to 26 weeks. That also includes family members who are concerned or caring for military individuals. Workers' compensation, there is no limit for the amount of leave. And, you know, we have cases in Ohio that go back years and years and years, and somebody will try to claim temporary total compensation. And of course, we have permanent total disability. So there's no limit on leaves under any workers' compensation law that I'm familiar with in any state. Maybe Indiana. Medical documentation. As we indicated earlier, every one of these laws has a medical component to it. Under the ADA, that's why I posed the question, medical examinations or inquiries regarding an employee's disability are somewhat limited. However, the EEOC has said that COVID-19 testing is fine as long as it is performed in a non-discriminatory manner. But normally, the only way you can get any kind of medical information is when there is an objective, first, the actual pre-employment. Post-offer, pre-employment, you can do an examination. But otherwise, it's based on whether there's a real legitimate concern that somebody's a danger to themselves or to others, or a concern that they're not able to perform the essential functions of the job. FMLA, you have to have medical certification. And that gets to be sketchy sometimes as to what people supply employers. And workers' compensation. And this is a point that Rob will probably talk about later in the presentation, but employers really ought to get into the medical documentation in a workers' compensation case from the very beginning, right?
It's the most important part of it, absolutely.
Yep. Restricted or light duty. Under the ADA, it doesn't come up very often, but upon occasion, an employer can be held responsible and can be required to offer a restricted duty job if it's a reasonable accommodation and doesn't create an undue hardship. I would note that under the ADA, an employer is not required to create a new job for someone. That's why it's important to have very up-to-date and detailed job descriptions. Now I'm going to jump over and go to the workers' compensation part. An employer ought to have a very robust light duty, restricted duty job program for employees to limit the exposure for workers' compensation. And then it gets to be kind of a interesting interplay between the ADA and workers' compensation on restricted duty jobs. We have an entire memorandum on that subject. It's really not part and parcel of our presentation today. Just know that in workers' compensation, you can create a new job, and you might want to reduce your exposure to compensation being paid in a claim. The FMLA, you're not required to offer somebody a job, and they're not required to take it. Benefits while on leave. Are there benefits? Well, workers' compensation, let's go backwards. Not required to continue any formal benefits such as health care when somebody's on workers' compensation. However, once again, you have to treat everyone equally. So if someone is similarly situated and you provided them health insurance coverage for 3 or 4 months while they were on workers' compensation leave, but you don't do it for a different person in a different age group, then you're bringing some potential problems into your world. The ADA, there's no requirement to continue benefits, but once again, you can't discriminate. So if you're going to continue health insurance, for example, for someone on a couple of months of workers' compensation leave, and you've determined that a couple of months of leave under the ADA is a reasonable accommodation, you need to treat both of those situations the same. Under the FMLA, healthcare coverage must be continued at the same level as prior to the leave. So that's a brief summary of the 3 different laws, how they are the same and how they are different. Now we're going to launch into the COVID-19 dance in the FMLA paid leave world. I think first, let's talk about the expanded FMLA. We just said that between 12 and 26 weeks of leave is offered for individuals to protect their job while they balance their life. Well, what Congress did in response to COVID-19 was expanded the FMLA, and the law is good through December 31st, 2020. My guess is it will continue. You think so too, Rob?
Oh, yeah, absolutely.
Yeah, they're going to renew it probably for another 6 months, maybe through May, maybe even through June. But this is a very detailed slide, and so is the next one. We don't expect you to be able to read all of this. We can make these slides available to you. So contact us. You have our contact information, and Carrie will also explain that to you at the end of the webinar. This is a temporary amendment under the FMLA. And what makes this a little bit different than regular FMLA is there is money involved. So the employer is required to pay some money to the individual who's taking time off under this part of the act. And I would also say that employees cannot stack their weeks on top of each other. So 12 weeks is 12 weeks is 12 weeks. It doesn't become 24 weeks. This is when somebody is taking a leave because they're unable to work because they have a child at home and they need to care for the child and normally where they would go, either to school or to some kind of daycare, is closed because of COVID-19. And that's the most common time that our office has been involved with this law. There's a lot of details to this law. Individuals have to be employed by an employer with fewer than 500 employees. So this law does not affect very large companies, only small companies, smaller. I mean, if you have 490 employees, in my mind, that's a pretty big company, but under the federal government's definition, that's not a very large employer. Similarly, if your business has less than 50 employees, you may be exempt from this law if you can validate that providing such a leave to your employees would affect the viability of the business. Frankly, we have not seen that in our office. We may have some clients online who are doing this that we're not aware of. That, you know, is just something that we haven't dealt with. But I have gotten some phone calls on that. It's just I've not actually been involved with it. But you should be aware that that's the coverage of the law. Now, we talked about pay. The first 10 days of leave, and those are working days, it was a little confusing the way the law is written. Congress rammed this through really fast, so there wasn't time to look at each and every little detail and dot every I and cross every T. They mean 10 working days of leave is unpaid. After the first 14 days, so you see what I mean, this comes actually from the law. That's after the first 2 weeks, an employer must pay the employee no less than 2/3 of their usual pay, but it's limited to $200 per day and a total of $10,000 for the entire 10 weeks of pay. I think, Rob, the employer then at the end of the year gets some kind of tax credit.
That's my understanding, yes.
Okay. But that's not the subject of our webinar.
And that all may change depending on election results and the law.
Mhm.
You know, right now, no one wants to agree to anything. So ultimately, we'll have some clarity at sometimes in our lives as to what all that means.
We hope. We can only hope.
We can hope.
Hope springs eternal.
Absolutely.
There's one. We do have some healthcare providers online, and what I will call the direct care providers are exempt from this law. So a doctor, a nurse, an emergency care provider, 911 responders, they are exempt. Until recently, it was determined that any employee in that business was also exempt from this provision. However, a recent court decision in August determined that only direct care providers are exempt from this law. So, little quirks here and there. As the law goes, everything gets worked out over time. But I don't want to get into any more details. Do you have anything you want to add on this, Rob?
I think you've covered it.
All right, that's it for the expanded FMLA. There is another component to the Family's First Coronavirus Response Act, FFCRA. There's an emergency paid sick leave, and I'll just dance on this real quick. Once again, fewer than 500 employees, and there is no coverage. The law expires December 31st, 2020. The bottom line on this is, if somebody is sick with COVID-19 or they are out of work because they have the symptoms and signs of COVID-19 and they've been told to quarantine, and it goes on and on. There are actually 6 different reasons that an individual can qualify for this emergency paid sick leave. It is 2 weeks of pay, and then there's a maximum in there of $511 per day. Now, why are we covering this in this webinar? First off, it's directly related to COVID-19, which is directly related to our fact pattern involving COVID-19. But also, we wanted to bring this to your attention because this is a real exposure, a real risk exposure for employers. In that you cannot retaliate against someone for exercising their rights under this law or both of these laws, nor can you discriminate against someone for exercising their rights under these laws. We have now had 3 different cases in our office involving an allegation, amongst other things, of retaliation and discrimination for using the Family Medical Leave, expanded Family Medical Leave Act for COVID-19. So just be aware, you have to be very careful in today's world. And frankly, there are a lot of reasons for that. Employees are uptight, employers are uptight, everybody's uptight. Employees are really concerned about their jobs, and they're going to find any way they can to try to get the money flow coming in. So just beware of that potential issue for discrimination and retaliation. And I believe that we are now moving into the actual fact pattern. Rob?
Before I talk about the fact pattern, there's a couple things I wanted to set forth in the beginning. The first is that some of you probably know that on September 14th, Ohio did pass a new law concerning COVID and workers' compensation. It was House Bill 606. That bill dealt with and deals with essentially people that are exposed and whether there is civil liability. Is there any immunity for tort or professional discipline that could happen? And originally when this was going through the legislature, there was a provision involving workers' compensation. And that provision, which ultimately was struck down or not made part of the law, essentially said that they were going to create a presumption of compensability for COVID-19. In the law, there are 2 versions of it, but primarily they were talking about healthcare workers, people in the industry that are at higher risk. As this went through the politics of our state, that provision was dropped. So there is no presumption that COVID-19 is a compensable occupational disease or injury now. And as I'll talk about in a minute, that means we have to deal with the existing law concerning primarily, in my opinion, occupational disease. There is an exception to that, and that is that if someone is essentially recklessly disregards the consequences, willful or wanton conduct, then there would not be the immunity or protection from civil liability. And that's pretty much, if you think about it, akin to what we have with intentional tort in Ohio. The language is a little bit different, the standard is a little bit different, but if you are an employer and you are willfully or wantonly disregarding COVID-19, you're not taking any steps, you're not doing any provision or any protections for your employees, I would not sleep well at night thinking that you have civil protection or civil immunity from an action. This situation affects everyone, and I think Carl has talked to a lot of you, and we've done a lot of handbooks in this office, and we've written a lot of policies concerning COVID-19, and I would suggest to you very strongly that if you have not considered that, you should consider it, because not only is it a best practice protecting your employees, but you also may be protecting your own self or your company by doing it. So just keep that in mind. The second thing before I address the fact pattern is let's talk about political reality. And those of you that know me, I think understand that I am big on practical application versus maybe technical construction of the law. Now, both are important, but let's look at where we are today. Ohio workers' compensation is a system that was created to pay benefits. That's what the law says. The law also says the Ohio Workers' Compensation Statute is to be construed liberally in favor of claimants. Those things are the case. Now, as you'll hear from my presentation in a moment, to prove a COVID-19 case is tough. The occupational disease statute and the law did not contemplate this. And a strict understanding or interpretation of the law with regard to COVID-19 would lead any scholar to the conclusion it's not compensable. However, in workers' compensation, we have an administrative process. You have people that are sick. You have people that have probably been exposed, maybe at work, maybe somewhere else. And in many cases, there's unfortunately very dire consequences. My experience, and I think Carl will tell you this as a former hearing officer also, is generally in the administrative process, these are very tough cases to win. However, if the case ends in court, courts apply legal standards, rules of evidence, requirements. So if you have a claim that you believe is not compensable, your true remedy may eventually be in court. Now, a lot of these claims, fortunately, are not real significant. That, you know, most people get better, and they're going to be off work for a period of time. They're going to get better and come back, and thank God for that. That's not always the case. You could have death claims. As our fact pattern shows, you can develop other illnesses that may be related or may not be related. So I'd like you to keep those things in mind as we go through this. Now, I'm going to read to you the fact pattern. It's up on your screen, and I'll go through it quickly. Then we're going to go through some of the basic standards, and then we'll answer any questions you have with regard to the fact pattern or how we think this would apply. Disclaimer alert, nobody has the complete answers to these questions. These are our opinions that we have formulated from practicing law a long time and dealing with the people. As you can see from the fact pattern, our scenario involves a small manufacturing facility that has 100 people. It's open and applying with the law and the protocols. They're monitoring temperature. They're checking symptoms. They're doing the things that you're supposed to do. They have obviously have a policy they've looked at. They haven't ignored things. They have a person that works on the line. They call our HR on Friday, and I think we've all experienced this, and they say they're ill. They're having COVID-19 symptoms, and as all of you know, those symptoms oftentimes mirror allergies and the flu and a lot of things. And they aren't able to get a test result right away. Now, unfortunately, that's the reality of where we live. Sometimes some places have rapid testing, some don't, and it seems to change. So if I had symptoms today and I wanted a rapid test, I knew at one time in this area I could go to Bowling Green. I've been told that's not the case anymore. You know, at any rate, you don't know what to do. She has a husband that works in a different part of the plant. Now, obviously, there is transmittal of breathing between the two. What do you do? Well, she takes the test. She tests positive. She's hospitalized. The husband self-quarantines for 14 days, which is absolutely right. And the claimant then files a workers' compensation claim. And our fact pattern, that's allowed through the agency to the SHO level, grants it, and they award compensation. Now, there may be offsets in that depending on what other types of compensation they could have received or may have requested. And while they're waiting for the a hearing in front of the full commission, which you may get, you may not, the lady's diagnosed with another condition, which is Guillain-Barré syndrome. I didn't say it correctly, but essentially that's a neurological condition that can be the result of infection, but generally is considered to be idiopathic. In other words, we don't know what causes it. She develops that syndrome. She has weaknesses. She says she can't work. The company has an IME. The doctor says they can do white duty. So what do you do with these scenarios? What do you do? Well, the first thing in this fact pattern to remember is that if there's a question as to the compensability of this claim, you're probably going to have to go to court to fight it. Does it make sense or not in this scenario? It may.
It might.
It could. The second thing is the subsequent condition that developed. Is that a result of COVID-19 or is that the result of some other infection? Neither of us are qualified to answer that question. Only a physician can answer that question. but that's something you have to consider. So even if the underlying claim is allowed, you need to consider whether you're just going to pick up something that might be the result of it, could be the result of it, or is the result of it. So those are a couple things to remember. The other question, and I'll ask Carl this before we go on, you have an employee that comes into the plant and they work in a plant. She calls off sick and says, I'm having symptoms, all right? And you look at it and you say, oh, okay, we're waiting on the test. It comes back, it's positive. Does this employer, and the husband is quarantined, does this employer have a responsibility to A, notify all the other employees in the plant, or B, shut the place down?
Well,
I should have told you I was going to ask that
I was
question
going to say,
beforehand.
for our audience, this is totally unplanned.
I like to see a sweat.
How about this? Classic lawyer answer. It depends. Here's what we always tell our clients. You need to protect the health and welfare of your employees first and foremost. And by doing so, you almost nearly are always in compliance with all the other rules and regulations. So in my mind, it depends on the work atmosphere. If you're in a very large facility and the employee is tested positive, then I think it's prudent to notify those that she worked around in the area and determine who was exposed to her. Do a deep cleaning, quarantine. She has to be quarantined. You would ask the other employees in the area she was exposed to how they're feeling. If they have any signs and symptoms, then they need to be taken care of. They probably would need to quarantine at that point. There is the question of the husband. I mean, he's going to be off, perhaps taking care of her. He ought to be quarantined, and he may be subject or may qualify for the expanded Family Medical Leave Act benefits.
And these questions aren't hypothetical. I know we've had a couple employers, one in particular, that had almost this very scenario. We're not this creative to come up with facts. Carrie may be, but we're not. But the bottom line is they did exactly what Carl suggested, and that is they took the person out, separated the employees, tested the other employees, did some contact tracing, reported the situation. This was a larger manufacturing company, and they I think they actually were shut for a day or two, but they remained open, and thank goodness there's been no further problem, knock wood.
And there are all kinds of other things that spring out of this we don't have time to cover, but you have OSHA that comes into this, OSHA recording, the kind of cleaning that goes into the facility, how long people need to stay away and how long the quarantine. So like this could go on and on and on, Rob, if you want to.
I think it does. Okay, I think you probably have gathered from, as we've talked before, but it's very important that any leaves with workers' comp and the FMLA should be run concurrently. And I don't think there's really any true exception to that. Sometimes you can't because of the way the recording is, but if you can do it, you need to do that. As you're going to see, and I guess this is a common sense thing to remember, but it doesn't always happen. I think it's sort of like government. We have 3 branches, and they don't always remember to consult each other. And you need to have your team involved. You aren't always going to have an FMLA, an ADA issue, and a workers' compensation claim going on. But you may, and there's more likelihood of it now than there was. So you need to consult your TPA, your lawyer, your HR people, specialists, and issues with regard to termination are relevant. You start firing somebody with a COVID-19 case, you got issues, to say the least. Now, I'm not going to make general statements here because that's all very fact specific. Same thing with leave. Discrimination. Are you treating someone differently than someone else? And workers' compensation. Are you retaliating? You know, we have provisions in our workers' comp law involving retaliatory discharge. You need to talk to each other. And, you know, thank goodness so many of us are working remote part of the time or all the time. You know, use your Zoom, Teams, whatever your software is, use it and consult each other. Because if you don't, you'll be talking to us at some point, and at that point, it becomes much more difficult to solve the problems. Okay, Carl mentioned initially in workers' comp there are two types of claims, and there's actually some variations, but there's an injury claim or an occupational disease claim. I don't really think that there's a real solid argument that COVID-19 would be an injury. Now, that there are some exceptions, but typically if it's going to be pursued, it's going to be pursued as an occupational disease. Well, what's an occupational disease? The definition is in front of you on your screen, and it was written by a lawyer with too much time, I believe, on their hands, because it's wordy. It doesn't make a whole heck of a lot of sense. And for those of you in the area that practice here and do this, it's really hard to interpret. But what it does say is it has to be contracted at work. And some of the slides will show in a minute. That's easier to say than to prove. It has to be by its causes and the characteristics of its manifestation or the employment result in a hazard that distinguishes the employment and character from employment generally. Okay, what the hell does that mean? Excuse my French. The bottom line is something about work has to be unique. Healthcare claims, and that's what we've seen most of the COVID-19 claims, may very well create that situation. You know, if you're taking care of sick people and there's a greater exposure for that than working in a law office or at a plant, that's something that's there. And it has to be a different degree, a higher degree. It has to be more likely that you're going to get it doing it than the public in general. So essentially, you got to be in a higher risk scenario. And this provision is also called the Christ case criteria, KRISE. And originally, that was a case that essentially defined an occupational disease, what you needed, and that's been codified into the statute, which now does define occupational disease. So, COVID-19, the rhetorical question is it an injury? Is it an occupational disease? This is, you'll see on the next slide here. And to use Carl's wonderful phrase, it depends. Or as our partner Rob King would say, that's a really good question and it's a gray area. Well, I think both of those are true statements and they're good lawyer answers. But the reality is, I think it's an occupational disease, and that's how the ones we've had have been pursued. I think we've had 3 or 4 of them in the office, so we haven't had a ton of these. Although you talk to people around, there's more and more of them coming through. And the other part of this is, right now, if people get well, generally compensation isn't an issue because they've been paid through another source. So I think that's kept things on a little bit lower level. But as I said initially, think about this. Anytime you have a situation where you have an awful disease, you can talk about asbestos and mesothelioma, and you know, we've done a lot of those. There are going to be plaintiffs' lawyers that are looking for actions. Now, I said that we have immunity at this stage, but there are exceptions, and I didn't mention that the law that we passed involves claims from March 19th, 2020 through right now, September 30th, 2021. So it's not an absolute protection. As Carl mentioned with the federal law, it has a sunset clause. Now, will it be extended? Probably, but will plaintiffs' lawyers be looking for actions, the intentional tort action? Bet your bottom dollar they will. So it's there, and you need to be aware of it. So how do you defend one of these things? What do you do when somebody tests positive? Well, it's like most claims, you need to have medical evidence and you need proof of exposure. Was it exposed, or was the person exposed directly at your place of employment? And truly, the slide says in theory, but in reality, that's hard to prove. I come to work, I'm around people, I develop COVID-19. Did I get it from Carl? And we're sitting behind plexiglass. I'll let you all know we're preaching what we say. Or did I get it when I went into Kroger or some other place to pick something up? Did I get it from touching a door handle? We truly don't know. Now, as I said, there are people that are probably higher risk than others, the healthcare workers and first responders that, do all these things for us, they're at a higher risk than others, but we truly don't know. There are a lot of people that have developed the condition, and they truly don't know where they got it. Other avenues, was personal protective equipment provided by your employer? Were you using it? It's really easy to say that everybody should wear a mask, and they sure absolutely should. But does everyone do that? And all of you, I can attest that I'm sure there have been places where people don't do it.
And there is another argument on this, and that is although the facial coverings, the cloth masks and the temporary masks do provide some protection, what they really protect are the droplets flowing out of the speaker's mouth, just like mine right now. The mask kind of keeps them stuck around me. But unless employees are wearing an N95 respirator, which is not required under regulations, they are still going to be exposed to the droplets, and that's how the virus is transmitted. So yeah, it's difficult to determine causal relationship.
Well, it's the other thing. What are you doing in public? Are you going to out to dinner? Are you going to events? And there's been a lot of talk about some of the campaign events. Are those super spreader events? Mm-hmm. What's going on? There's a lot of questions that none of us really know the answer to. And the other thing is, what about your kids or your family? Like our fact pattern, the spouse is exposed to the other spouse.
Right.
And that happens. And if you have children or anybody else, they can be exposed and they can bring that to you. And I guess that, comes into where all the things we've heard about, older people are more susceptible. And how does that play? If someone has a greater risk factor for contracting COVID-19, are they evaluated differently than someone that doesn't in your workforce? And the answer probably is, in Ohio, we take people as you find them. Right. So the fact that I have, and I'm lying here, but if we had an 85-year-old person.
You're getting close.
But if you had someone that is a high-risk group or someone that's diabetic, or you all know the risk factors here, that's a factor also. And, the test. Okay, you also need to look at the test, and you need to look at the actual test. But there are so many different types of tests. We have rapid tests, we have antibody tests, we have a lot of different things that are out there. And I think the thing that all of us would probably agree right now is whether we like it or not, there is not a unified voice as to what type of test you have, which is the most effective, all of those things. Now, unfortunately, a lot of that is a result of a political season and people on both sides looking to gain a position. But the reality is, most of us that I think are reasonable and trying to do a good job for employers, all we want to know is the truth, what it is. And, right. Unfortunately, you can look at the CDC, yes, and you can look at the Ohio site and the Hawaii and all those things that we have. and they're not necessarily consistent. So it makes it difficult. As with any workers' compensation claim, and with anything, documentation is the key to success. You know, as they say in real estate, what's important? Location, location, location. In workers' compensation, FMLA, ADA, what's important? Documentation, documentation, documentation. You got to do it. The test results. We've had this in several claims. They just say, well, the person has it. Well, so what? I mean, it's bad, but you need to have the actual test, not just some letter, so-and-so tested positive for COVID-19. Policies, like I said, it's so critical that you have written policies on this. And I think that pretty much, I'll just say my own view. I think every employer really needs to make sure that their employees in open areas or high-risk areas are wearing masks. And I think that happens in most places, but you know, we're on the 19th floor of the PNC building, and we're not supposed to have more than 3 people on an elevator. But I got to tell you, every now and then somebody will get on and they won't have a mask on. Well, that's irresponsible. But it's also our responsibility as human beings is to close the door, say, I'm sorry, take the next elevator, because we need to do that. You need to do that as an employee. And finally, witness statements if you can. You know, maybe Carl told me that he was spending the weekend at a bonfire drinking beer and watching the Ohio State football game this Saturday, and there were 150 people there, and he was having a great time. Then he was in the hot tub and all this stuff. You know, that sounds really good right now, but it also may be a really dumb thing to do, and also that may be the source of his exposure. So I think those are things that you got to keep in mind.
Is COVID-19 a disability under the ADA? And is it a serious health condition under the FMLA? Or one or the other, or neither? So, you know, in normal circumstances, if this was a webinar, we would do a polling. And we would get your answers and just try to see, you know, get the pulse of everybody there. I think probably COVID-19 would not qualify as a disability under the ADA, but then again, I know a lot of business people don't like this, but you have to say it depends. There are a lot of factors involved. Normally, a disability under the ADA involves a chronic condition that is permanent in nature. COVID-19 could result in that. We don't see those cases, at least we haven't, but what do you do if somebody develops that, what is that, Guillain-Barré syndrome or whatever?
Guillain, I think is how you say it.
That could be end up being a disability, and also it probably is a serious health condition. We recommend in that case, if it's a workers' comp injury or occupational disease, that FMLA time be run concurrently with workers' comp disability. It allows the employer to regain control over the leave. And also, at least in Ohio, the employer has the absolute right to do that. Just a quick review, these 3 laws have different purposes, but as you can tell, they do intersect. So I think we'll take questions. I know we went a little bit longer than we thought. We went about an hour, but Rob and I are still here. We're able to take questions, take your comments, and if we have none at this point in time, please contact us. You have our contact information. This is a moving target in COVID-19. It's continually developing. I would say that different states are on the move, requiring more and more from employers. Some states actually require a written COVID-19 response plan that includes actually in writing a formal policy, how you're responding to it. What do you do if somebody gets it? What kind of training have you done? What kind of training are you doing? So beware of that in the future. And we will do 2 more webinars focused a little bit more in different detail on each of these laws.
All right, I'm only seeing 2 questions right now. The first one is regarding the defense of the workers' COVID claims, and they want to know if the employer can investigate the employee's after work activity, like on social media, to determine possible points of infection.
I think the answer is absolutely yes. Now, you can do the investigation. I would suggest that you would talk to your HR people and also to your lawyer, depending on how you want to use that information, but you clearly have the right to investigate that, yes.
Yep, and you should.
And you should. And I'll say this much, even in a workers' compensation claim, we do a social media check on any new file that comes in. One today I just looked at, coincidentally, where the person didn't report an injury, and they were on social media talking about their thumb injury, and they made no mention of any industrial injury and said, yeah, the symptoms started while I was off on a COVID-19 when the place was shut down. So there's a treasure trove of information there. So yes, you can do it, and you should.
Did Rob mention that there currently is immunity regarding intentional tort due to COVID?
I think I inferred that. I didn't say specifically intentional tort, but yes, there is. That is House Bill 606, became effective on 9/14 of this year. However, please note it only covers right now the period between March 9th, 2020 and September 30th, 2021. So yeah, we have it. It's there, but there are, like with intentional tort, there are exceptions. So yeah.
That may be, Carrie, an answer further expounding on that. Remember, that does, at least until December 31st, 2020, provide immunity for an intentional tort action, but the employer is still at risk for discrimination, retaliation, and all of the other forms of action that an employee would have against an employer in how they handled COVID-19 issues.
Yeah, just to clarify, it's currently in effect till September 30th of 2021. So
Okay.
we have a little more than, I guess, a year. Not quite, a little less than a year now,
Right.
I guess. So anyway, if there's no further questions, we'd like to thank you all for listening to two of us talk about things we like to talk about, and
socially distanced.
and so while socially distancing.
And have plexiglass between us.
All right, thank you everyone, and I hope you all have a good day, and please stay safe.